Before we begin, a brief note. This presentation builds directly on our earlier video explaining Section 136 of the Law of Property Act 1925 and how legal title to a debt is transferred. If you have not yet watched that video, I recommend doing so first, as it provides essential background that will make this presentation clearer and more valuable. In this video, we move from legal title to transparency and to how UK GDPR operates once data is being processed by any corporation. From legal title to transparency, in the previous video, we examined a foundational point of English property law, that a debt is a form of property, a chosen action, and that legal title to that property can pass only by strict compliance with Section 136 of the Law of Property Act 1925. In this presentation, we take the next logical step. We ask a different question. What happens once an organization claims to be entitled to use your data because it says it owns or enforces a debt? This is where data protection law, specifically UK GDPR, becomes relevant, not as a weapon, but as a transparency framework. Why legal title still matters in a data context. Legal title is not a technicality. It determines who has standing, who is entitled to act to enforce, and crucially, to process personal data. An organization that claims to collect, enforce, or manage a debt is implicitly asserting authority. That authority must come from somewhere. UK GDPR does not replace property law. It assumes that underlying legal relationships are real and lawful. So before we even ask how data is processed, we must understand why that organization believes it is entitled to process it at all. Debt, data, and controller status. Under UK GDPR, an organization that determines the purposes and means of processing personal data is a data controller. Debt collection agencies routinely act as controllers. They decide how data is used, who it is shared with, and for what purpose. But controller status does not exist in a vacuum. It depends on lawful authority, contractual, statutory, or proprietary, to engage with the individual in the first place. This is where questions of assignment, ownership, and standing quietly resurface. The role of UK GDPR in this context. UK GDPR is often misunderstood as a privacy shield alone. In reality, it is a transparency regime. It exists to ensure that when organizations process personal data, they do so lawfully, fairly, and openly. One of its core assumptions is that organizations can explain themselves, not rhetorically, but evidentially. Article 15, the right of access. Article 15 of UK GDPR provides what is known as the right of access. This is not a hostile right. It is not an accusation. It is a request for clarity. It allows an individual to ask a simple question: what personal data do you hold about me, and on what basis are you using it? This right applies regardless of whether a debt is disputed. It applies because data is being processed. What Article 15 actually requires? Article 15 is exact, it is precise, it allows an individual as the data subject to send a subject access request, commonly called the SAR. The SAR under Article 15 requires a controller to confirm whether data is being processed, the purposes of that processing, the categories of data involved, and the legal basis relied upon. Where an organization asserts legitimate interests, it must explain what those interests are, not merely state that they exist. Transparency is not satisfied by labels. Legitimate interest is not a magic word. Legitimate interest under Article 6 is not automatic. It requires a real interest, a necessity assessment, and a balancing exercise against the rights of the data subject. An organization must be able to articulate this reasoning. Too many times, corporations simply state that they have a legitimate interest to process data without stating what that actual legitimate interest is. The fact is, if it cannot explain its interest, then it cannot rely on it. This is not activism. That is not argumentative. It is black letter GDPR. Why transparency comes first. Importantly, Article 15 operates before disputes escalate. It is about information, not enforcement. It is about gathering details of what these corporations are stating that they are relying upon when using terms such as legitimate interest. Courts and regulators consistently treat transparency as foundational. Without transparency, you have obfuscation. This goes against the principles of GDPR, transparency and fairness. If the processing of your private information cannot be explained, then the very lawfulness of that processing is immediately in question. This is why your access rights matter even before any claim has been filed. This is why your access rights must be answered clearly and fully. What Article 15 is not. Article 15 is not a demand for payment, not a declaration of any type of breach, and in no way any type of litigation threat. It is simply a request for an understanding of how and why any corporation is using your private information. We all have a right to a private life. So if any corporation contacts you stating that they are using your private information, your data, then you have a right under UK GDPR to request what data that they are using, how and why they are using it, and under what lawful reason that they are processing your data. Mischaracterizing it as aggressive or abusive misunderstands its purpose entirely. Data, authority, and accountability. When organizations act with authority, transparency is effortless. When a corporation has a lawful reason to be processing your data, they will easily and clearly explain and demonstrate what lawful documentation that they possess that creates this lawful basis for processing your private data. When authority is unclear, explanations become evasive, language becomes elusive, obfuscation becomes apparent. This is why GDPR matters in debt contexts, because it forces clarity where opacity has become routine. If you have not given consent for any corporation to process your data, then the legitimate interest needs to be clear, concise, and easily shown. The educational purpose of the Article 15 process. The purpose of understanding Article 15 of the UK GDPR is not confrontation, and it is not aggression. It is legal literacy. Article 15 exists to give individuals visibility and control over how their personal data is being used, by whom, and on what legal basis. It is the transparency mechanism that prevents organizations from operating in the dark while individuals are left guessing. In the context of debt collection, this matters because personal data is often processed, shared, and acted upon long before lawful authority has been properly established. A subject access request is therefore not a threat. It is not an accusation, and it is not a refusal to engage. It is a lawful request for clarity. Through Article 15, an individual is entitled to understand what data is being processed, the purpose of that processing, the lawful basis relied upon, and whether that processing is actually justified in law. This process allows engagement to take place calmly, precisely, and on evidence, rather than fear, assumption, or pressure. In plain English, this isn't about arguing with anyone. It's about making sure no organization gets to use your data, chase you, or make decisions about you without being able to explain properly and lawfully why they are entitled to do so. Article 15 is how you turn uncertainty into facts. The purpose of understanding Article 15 of the UK GDPR is not confrontation, and it is not aggression, it is precision. Where an organisation claims a right to act against you, to pursue payment, to share your data, or to exercise control, the law expects that claim to be legible, accountable, and explainable. A subject access request is not a challenge, it is a question. It asks, what data are you using? Why are you using it? Where did it come from? And on what lawful basis does that use rest? In the context of debt collection, this matters because data processing often runs ahead of legal ownership. Article 15 allows an individual to slow that process down and insist on clarity before assumptions harden into enforcement. This is not about threat, it is about restoring balance between a private individual and a corporate system. In plain English, GDPR gives you a lawful way to say calmly and formally, before you act against me, explain exactly what you think you're entitled to do and why. Legitimate interest under Article 6(1)(f) is not automatic, and it is not self-declared. It must be identified, explained, and defended. When a controller relies on legitimate interest, they are required to show three things: that the interest exists, that the processing is necessary to pursue it, and that the individual's rights do not override it. Transparency is what makes that assessment possible. An individual is entitled to ask, what interest are you relying on? How did you assess it? What balancing exercise was performed? In the debt context, these questions become especially important where ownership, authority, or assignment is unclear. Legitimate interest cannot be used as a blanket justification for silence. In plain English, if a company says we're allowed to use your data because it's in our interests, the law says, fine, now explain that interest properly. Data, property, and consumer law. Data protection rights do not exist in a vacuum. They operate alongside and often intersect with other areas of law, including property law and consumer protection. Where an organization claims authority over a debt, that claim has consequences beyond accounting. It affects who may lawfully process data, who may share it, and who may act upon it. Legal title matters here, not as a technicality, but as a boundary. If an organization does not hold legal title to a chosen action, that absence of ownership is not cured by internal records, commercial explanations, or industry practice. It directly affects the legitimacy of downstream data processing. This is why the concept of legitimate interest cannot be treated as self-evident in the debt context. A controller relying on Article 6(1)(f) must be able to demonstrate that a legitimate interest exists, that the processing is necessary to pursue it, and that the individual's rights do not override it. That assessment cannot be abstract. It must reflect the legal reality of the relationship being asserted. Where ownership, authority, or assignment is unclear, the balance shifts. Data protection law does not permit enforcement narratives to run ahead of legal proof. And where multiple legal regimes apply, property, consumer protection, and data protection, none of them can be selectively ignored. Transparency is what allows those systems to align. In plain English, GDPR doesn't stand on its own. If a company says it owns a debt and uses that claim to process your data, the law expects that ownership to be real, not assumed. They don't get to say, we have a legitimate interest and stop there. They have to show what that interest is, why it exists, and why it outweighs your rights. If they can't explain that clearly, the problem isn't your questions, it's their authority. Why transparency matters. Transparency is the point at which legal claims meet reality. When an organization asserts authority to pursue payment, to instruct agents, to share data, or to threaten enforcement, transparency is what determines whether that authority is real or merely asserted. UK GDPR does not allow organizations to operate behind closed doors while exercising power over individuals. If personal data is being used to support a claimed legal position, the individual is entitled to understand what data is held, how it is being used, and on what lawful basis that use rests. In the debt context, transparency becomes especially important because claims of authority are often made before proof is produced. Phrases such as commercial sensitivity, industry standard, or internal documentation do not override statutory obligations. They do not displace the requirement to explain lawful basis. They do not remove the need for accountability, and they do not extinguish the individual's right to ask questions. Where transparency is refused or curtailed, the law provides further mechanisms, regulatory, supervisory, and ultimately judicial, to ensure that claimed rights can be tested against evidence. This is not about escalation for its own sake. It is about ensuring that legal power is exercised only where it genuinely exists. Transparency ensures that enforcement follows proof, not the other way around. In plain English, if a company wants to act like it has legal authority over you, it has to be willing to explain that authority. If it hides behind vague phrases or refuses to answer lawful questions, the law does not say accept that. It says show your basis or stop acting as if you have one. So, when the time is right, we may feel the need to move towards assistance via legal means and have judges reading through alleged legal titles. This is why you need to study GDPR and be able to stand on your rights when needs be. What we have done here is establish the foundations. We have looked at legal title, lawful authority, and why transparency matters when organizations act against individuals. The law does not expect you to accept assertions at face value. It expects claims of authority to be capable of explanation. In our next video, we will turn to the practical mechanism that makes that transparency possible, the subject access request under Article 15 of the UK GDPR. We will explain how the SAR process is used to gather information, how it brings lawful basis into the open, and how it allows individuals to respond calmly and lawfully when faced with silence, deflection, or incomplete answers. This is not about confrontation, it is about understanding how the law expects power to be exercised and how information must come before enforcement. If you have not already watched the first video on Section 136 of the Law of Property Act 1925, we strongly recommend doing so, as it provides important context for what follows. Transparency is not optional, and the law provides the tools to insist upon it.